probate and asset division after a loved one's passing. I'm going to talk about the steps that need to be taken, what the process looks like, timelines, and things of that nature. Again, this presentation is for informational purposes. It is not legal advice and is not a substitute for consulting with an attorney of your choice regarding your fact-specific situation, and it does not create an attorney-client relationship. Today, we're going to help everyone understand the Kansas probate process. This is Kansas specific and only applies here to process in Kansas pursuant to Kansas law. We're going to learn how assets are inventoried and distributed, the responsibilities of the executor and administrator, how to minimize disputes amongst family members and other beneficiaries, and we're going to highlight some of the legal requirements, what's involved in that probate, and the steps undertaken. So the first thing is what is probate? So probate's the legal process of settling a deceased person's estate under court supervision. The purpose of probate is to ensure that debts are paid, assets are distributed correctly, and the will, if there is a will, is validated and followed. Typically occurs in the district court of the county where the deceased person resided. Sometimes it can happen where they owned property, if maybe they were living with a family member at the time of death, or it could happen where they own other assets. When is probate required? Probate's required when a will needs to be used. It can happen if there is real estate that it's owned only in the decedent's name. It's not jointly held, or doesn't have a transfer on death designation for the real estate. And it can happen when there are other assets lacking a beneficiary designation, or there's personal property exceeding the small estate's limit. Not every estate needs to go through the full probate process. There's several different kind of levels of probate. Then there's also a small estates affidavit, as simply an affidavit requiring the signer to pay the debts of the estate, stating what the property is and that it's less in value than $75,000. This could allow you, if maybe there's just a car or a small bank account or something like that, that's the only asset of the estate. Maybe it was missed as part of a different planning process. Affidavit can be executed, and then that account distributed amongst the family members or the legal heirs. True or full probate has different levels of court supervision. Generally, the probate process starts by filing a petition and the will, again, if there is a will, with the court. Next, you're going to appoint an executor or an administrator. So an executor is appointed during the probate proceeding if there is a will, and then an administrator is appointed in the event there is not a will. Again, if there's a will, then the estate will proceed and distribute according to the terms of that will. And if there is no will, then the assets of the estate will be distributed according to intestate succession, which is basically the state's kind of default provisions, and we'll touch on what those are next. Once that individual has been appointed, they have to take an inventory and appraise the assets of the estate. Inventory includes finding bank accounts, maybe personal property, tools, vehicles, other equipment. If there's real estate, or maybe artwork, collections, maybe someone collects stamps or coins, something like that, getting those assets appraised so that they can be distributed. Notify creditors and pay valid claims. So creditors of the decedent can make a claim against the estate. The executor or the administrator is not personally responsible, but has to pay these claims from the estate's inventory and assets. So these could be things related to disposition of the body, funeral costs, final medical expenses, um, or any other number of debts, credit card debts, other personal loans, secured debts as well. File tax returns, and this could be a final tax return for the decedent, their final state or federal income tax return. If they were, employed and had withholdings, they may be entitled to a refund of overpaid state or federal income tax. That becomes an asset of the estate and something that can be distributed to the heirs or beneficiaries. In rare occasions, tax returns would also apply to estate taxes. Kansas does not have an estate tax. However, Nebraska, our neighboring state, is one of the few that does have a state level estate tax. And if there's real estate or something like that owned in Nebraska, the estate tax could be required to be paid on that asset. The federal estate tax does not kick in until I believe it's 13.99 million for this year. It is indexed for inflation and will continue to go up. So that applies to very few individuals. There's a distribution of assets left over after creditors' claims have been paid, and then finally closing the estate. And that closing process includes notifying the court that distributions have been made, and it could also include one more tax return for any income the estate earned. So again, this is not a tax on the assets of the estate, but in the event maybe the estate was holding a large amount of cash or had a brokerage account that was part of the estate and was earning during the time that the estate was open. We'll talk a little bit about the timeline, but an estate is going to take typically somewhere between 6 and 12 months. And the limit currently for needing to file that estate tax return is $600. So oftentimes the estate will earn that in interest or dividends, triggering the need to file that tax return. The estate does not pay the tax. Instead, the earnings are shared amongst the beneficiaries or the heirs, and then each beneficiary heir pays their respective share at their own marginal rate. So probate is not always a bad thing. Lots of people talk about avoiding it. We'll touch on that briefly at the end. But probate can be a good process because of the court oversight and because of the control that's involved in it, as a way to prevent or address estates that could be disputed. Or if you know there's conflict amongst the family or that some distribution that you're choosing or electing to make is going to be contested or is going to make someone unhappy. Okay. That said, if you're choosing probate uh, intentionally because of the potential for conflict, it's important that the executor administrator be prepared for that. And even in the best of cases, there are disputes that commonly come up. And some of these are things that the executor can address. Some of them that are going to be things that they're burdened with based on the estate. So ambiguity in documents can lead to conflict. Maybe the document internally is confusing or has multiple interpretations. Maybe one provision doesn't match with another. Or perhaps you have different documents and there's questions on which version is valid, which was the latest in date. Was it intended for this document or that document to control? Allegations of undue influence. Oftentimes, a family member may be living with someone, maybe not part of the family or part of the family, and that individual who is providing care takes a larger share of the estate than the other beneficiaries or heirs anticipated, and particularly if there was changes made to the estate plan um, during the care that was provided or close in time to death, that can oftentimes raise questions amongst the other beneficiaries. And then executor mismanagement. This could be a lack of communication amongst the other heirs and beneficiaries. It could be, um, making bad decisions with the handling of the money, the sale of assets. Um, Perhaps a asset is misidentified and sold at a steep discount when it should not have been. And again, all of these really, at the end of the day, are breakdowns in family communication, whether it was during the lifetime of the decedents or actions on behalf of the executor or administrator in the handling um, of the estate. The longer the estate goes, typically the greater chance there is for disputes as people begin to wonder, again, why are things taking so long, particularly, again, if it's not clearly communicated. Okay, so I talked about the executor has a lot of control, and their communication is key to this process. So, what are their duties? So, as the executor administrator, that individual has a fiduciary responsibility both to the estate and the heirs. So, they are tasked with marshaling the estate and bringing in and preserving assets of the estate. If the estate has debts, they are tasked with trying to collect on those. And again, they're trying to maximize the size of the estate and protect and guard the assets of that estate. Um, if it's real estate or other collections, it could be making sure that it's kept weather tight, that it's locked, that it's monitored. If there's renters, that the renters are, again, continuing to pay rent, maintaining the property, providing notice. It could be evicting tenants. It could be continuing to keep something rented to make sure that perhaps farm ground, whether it's tillable or pasture, does not go fallow and is rented, that the ground is continued to work, that cattle is continued to be run to prevent weeds and other waste to the property, not to mention the income, again, that's created. Uh, they have to pay the debts, the taxes, and expenses of the estate. So again, we want to make sure that um, properties stay heated, pipes don't freeze, that again, no asset is lost to a claim for taxes or something like that. And then provide a detailed accounting to the court. So after that initial inventory of the estate, continue to provide updates to the court and the beneficiaries as to the spending of the estate. The faster these things are done and the clearer the reasoning or the action is explained, the less likely we are to end up with those disputes again. Mismanagement can result in personal liability to the executor or the administrator, although that's rare. There we go. Asset inventory and evaluation. So again, we talked about this is one of the key parts and jobs for the executor and the administrator. It's one of the first steps that happen in the probate process after the appointment of the administrator. This is supposed to be to the court within 30 days. And again, getting it to the court timely is important. Oftentimes the court will allow additional time and it can be requested, uh, or you can provide a partial accounting to the court while you maybe await appraisals or other information like that as it relates to assets of the estate. The value of the property and the different assets that you're going to use as this valuation process is typically the date of death. So what was in the brokerage account as of the date of death, bank account, uh, value of the real estate that should be appraised using the date of death. Again, so you're going to be looking for real estate, bank accounts, vehicles, investment accounts, uh, maybe rented units or spaces where there could be additional items stored. And then also identifying jointly owned assets. Those are going to be handled outside of probate, but it's important to follow up on accounts and see, well, why is this not coming into the probate estate? Making sure that that's understood. Oftentimes people will know, well, mom or dad or my brother had a bank account at this institution or they had this vehicle. Why am I not seeing that on the inventory or valuation? And being able to explain, well, that vehicle was jointly owned or that bank account had a beneficiary designation. So it's not coming into the estate. Once this asset inventory and valuation is done, that allows you to know, okay, this is the value of the estate. These are the debts. These are the claims that can get paid. Once those are paid, now we know this is the amount that can be distributed amongst the beneficiaries and start identifying the percentages that they're going to get. So again, one of the first things to do once you have that inventory and evaluation, um, if assets need to be sold to convert to cash so they're distributable, you can. If it's a house that needs to be sold because none of the heirs are interested in taking it as part of their share, that can be sold. But then again, from those proceeds, before we can give money to the heirs or beneficiaries, we have to pay the debts and taxes of the estate. Again, taxes typically are only going to relate to any income tax owed by the individual um, at the time of their death. So again, maybe they're a small business owner or didn't have a lot of withholdings. That final income tax return could owe tax. Again, Kansas does not have a state level estate tax, so it's unlikely that any estate tax will be owed. And at the federal level, again, only comes into play if that valuation shows over 13.99 million. So typically this is not a tax question. This is almost always a paying of a debt. So again, you want to notify known and unknown creditors and then pay valid claims in statutory order. Known creditors, obviously that's easy. There's a notice that you can send them saying, this decedent has passed on such and such date. Here's where the court proceedings are. If you have a claim, you must submit it, and here's your deadline. So the question is, well, how do you notify unknown creditors? That's done by publishing in the newspaper. So under Kansas law, that publication satisfies your obligation to unknown creditors. Known creditors, though, are going to be, again, maybe the hospital or medical installation where someone passed, and there could be final bills related to their care during that last illness. The funeral home or any other individuals involved in final disposition of the body is another known creditor. And then as mail comes, and you see statements from Discover Card, Chase, etc., those become known creditors. If you know there's a lien on the house or on the vehicle, those are known creditors. We are primarily concerned at this stage with unsecured creditors. Secured creditors, so those that have like a lien that's recorded on equipment, um, a lien against a vehicle, or mortgage recorded against real estate, those creditors are going to get paid whether they submit their claim or not uh, through through that lien process. So if there is a mortgage uh, on some real estate, just like if it's sold outside of probate, if the administrator sells that property as part of the probate proceeding, the bank will get paid off first and the balance comes into the estate. If the real estate is to be distributed out to heirs, that mortgage will have to be satisfied from other assets of the estate first. Um, and the claims paid in statutory order. So Kansas sets out a priority of claims to ensure and protect creditors. Oftentimes, an estate will not have enough funds or assets to satisfy all of them. So, again, a priority order is established. It starts with the funeral home and disposition of the body. That also includes payment for last illness or expenses. Again, that medical care right at the time of death. Uh, Expenses related to handling the estate come next. Um, Secured creditors, and then finally is the unsecured creditors. So again, maybe just a personal note that's not secured, again, or credit card companies, uh, things like that, payday loans. Uh, those are the last things to get paid. When notifying those creditors, again, you're going to have a date, you have a timeline in there for them. If they don't make that claim within the time prescribed, then their claim is barred, and that's 4 months. So if someone is asleep at the switch, does not get their paperwork in, again, so that's why we talk about paying valid claims. Um, if they're prevented by statute because the claim is late, then we're going to keep that money in the estate to be distributed to the heirs or to settle claims with those creditors who did follow the proper procedure. So again, what happens next? You have the assets, claims have been paid, everything's distributed. If there's a will, it's easy. It's going to go um, according to who the beneficiaries are. Maybe three kids taking equal shares. Maybe one kid gets 60% and the other two get 20. But whatever the will lines out is how the property is going to go. In the event there is no will, then like we mentioned earlier, Kansas has kind of a default or fallback provision, and intestate succession is going to be followed. If an individual dies with no children but is married, the spouse inherits the entire estate. If the individual decedent is both married and has children, then they share equally. We'll talk a little bit about some exceptions to that. And when we say equally, it's not equal shares amongst all the individuals, but the spouse takes 50% and the children collectively, whether it's 1 or 15, share in the other 50%. And if there's no spouse or descendants, children, then parents or siblings of the decedent will inherit. Kansas statute has, I believe it's 7 degrees, essentially, to make sure that heir is found. Nieces, nephews, aunts, uncles, things like that have various rights in that kind of chain, in that ladder, designating where they fall. But typically, we don't get past this last one. Usually, we're in the situation with the middle one, where there is either children or a spouse. Um, so if there is children but no spouse, then the children take in equal shares. So some quick facts. This would talk and deals with when you have both children and a spouse. I mentioned earlier the kind of the default is that the spouse takes 50% and the children take the other 50. Can you imagine in certain circumstances that could lead to a spouse really be left, uh, in a situation where they become kind of impoverished and are not able to, you know, pay the claims of the children against the estate, particularly if the family dynamics are such that the children are in conflict with the surviving spouse. Kansas statute has two main provisions, though, that allow for protection of that spouse. So there's homestead protections, which again protects the marital residence, the residence where the spouse was living with the decedent at the time of death. So they're not left in a situation where they're without a home. And then a spousal elective share, which allows the spouse to make elections against the estate and even some of the non-probate assets um, based upon the length of marriage. Um, and that goes up to uh, the 50% mark as well. After, I think, 17 years of marriage, about 3% a year. There are other ways to avoid um, some of these things, transfer on death deeds, again, for real estate. And again, the fact that Kansas has no estate tax does make for some simpler planning um, because you're only concerned with the federal tax, and that again is quite high at this time. So how do we avoid probate? Again, you can use revocable living trusts, which we've talked about previously in some of our webinars. I encourage you to go back and look at those. Uh, and all of these things we've talked about previously, again, in more detail in other webinars. But again, transfer on death deeds are a powerful tool for real estate, although they do not have a ton of provisions or flexibility, but there are very easy and cheap thing to execute and get on record. Joint ownership, again, this can be both of real estate or other assets, vehicles, bank accounts, anything titled. Make sure that there's a joint owner on that survives your interest. And then finally, beneficiary designations. And again, this can include your traditional probate assets like bank accounts, um, or it could include insurance policies, retirement accounts, and things of that nature. Special things to consider, and this is both for the executor and the administrator and for anyone making plans. But each of these things creates special problems or unique situations that, again, an executor may need to deal with. Uh, Sometimes there is a closely held business, whether it's a small business or farming operation that's being run on a day-to-day basis by the decedent. Now, how do you protect that business interest? How do you keep that maybe running or again prevent some asset from going to waste during the probate proceeding? Uh, Real estate could be owned in multiple states. And then in that situation, we probate the main estate here, and then we record, and there needs to be probate proceeding in each of the other states where that real estate is owned. Uh, that each state controls that land as far as the distribution. If it's covered in the will, it's still going to go according to the terms of the will, but that will in the Kansas proceedings will have to be recorded and made of record in the other states. Digital assets and accounts. And this is not, when we say digital assets, a lot of people think I don't have crypto or I don't have NFTs, things like that. But it's not just that. It is, maybe your iCloud Drive, your Google Drive, Dropbox, all of those accounts where you have things stored, uh, photos, other memories, passwords, things like that. So again, making sure that we can get access to those things and that they can be provided and shared with family. Again, could be more of something on a sentimental basis, or it could be, uh, again, crypto or other digital assets that have real value. Um, these can be handled much easier outside of probate. Um, both Google and Apple have uh, within their systems. Um, they each have a different term, but I believe for Apple it's called a legacy contact, and I don't know, I can't remember what it's called for Google, but they do have a designation, and you can set that up ahead of time. Uh, on your death, another individual will be able to log in, take control of your account, and make sure, again, pictures are downloadable, can be distributed and shared with other people. Your password managers that are built into those emails for contact information, you know, information that's saved in those accounts, use for two-factor authentication to log into accounts, that all becomes accessible. As an executor, you may also end up in a situation where you're making distributions to someone with special needs or maybe a minor beneficiary. Oftentimes, the amount that you need to distribute will make a difference here as far as um, what does that what needs to be set up for that individual. Is a guardianship or conservatorship going to be needed to manage those funds, to protect them from maybe other creditors or family members? If it's a minor beneficiary, can we do this with a UTMA account or Uniform Transfers to Minor Act account? Again, so if you see these things as part of your estate, make sure you're planning ahead to handle them. If you're an executor, be on the lookout and know that if one of these situations applies to you, um, again, it's just going to take a little bit of extra thought and planning. Uh, doesn't mean anything's wrong with the estate or, you know, but it's going to likely just take a little bit additional time to deal with. So what are your next steps? So we kind of learned about what probate is, um, but probate is not something you got to worry about immediately. Okay. The probate process in Kansas can really happen at any time. There is kind of two kind of main windows for that we'll touch on briefly, but there's no real rush to get that started. Uh, you can need to first make sure you arrange for the care for dependents. So if the individual had minor children, or maybe a special needs family member or someone else residing with them, make sure that those individuals are cared for. Next, make sure that the decedent is honored and that their wishes regarding final disposition of the body are followed through with. It began as part of the planning process. Um, People can make these wishes, and they're often found in the healthcare power of attorney. That's where Kansas is designated that they should be as it relates to final disposition. Next, you want to secure property. So again, with real estate or maybe a vehicle, get the vehicle, if it's parked somewhere else, get it back to the decedent's property, get it someplace safe, make sure it's locked. There's not stuff, just laying in it. Make sure that Any real estate, again, is secured and weather tight. The windows are shut, doors are locked, etc. And then start collecting paperwork. Is there a will? What are the accounts? Where are their bank statements for? Um, is there a trust? Is there other estate planning documents that the individual had? And then finally, contacting an attorney to help you in the probate process to make sure that the proper steps are handled. This protects you as the administrator, the individual handling the property, again, from disputes maybe amongst family members, for claims from creditors who weren't properly addressed. So, uh, the probate process, again, in these steps, again, this isn't something that has to happen overly quick. If there is a will, you do have a legal obligation to present the will and make sure it's admitted to the court and preserved. A will must be provided to the court within 6 months of death. Um, when you present that will to the court, you have two options. You can, again, just have it preserved. Say, here is the will. It does exist, but we don't know if we're going to need it because we don't know if the estate has any assets. Maybe all of the assets are in a trust or they all have joint owners on them. Oftentimes in situations where the decedent was married, bank accounts, vehicles, home, things of that nature are all jointly owned. And there isn't necessarily a need to probate. The personal property and belongings can be transferred with a small estate affidavit. But the will, there's again a legal obligation within 6 months of death, if you know of a will, to at least get it preserved with the court. You can also choose to start the probate process within 6 months. 6 months is the time that creditors have to make claims against the estate. There are a few exceptions to that, but generally speaking, there's 6 months to make a claim against the estate. If there is no will, again, the estate can really kind of be opened at any point that the family is ready to do so. The only caveat is you cannot start distributing property prior to that probate process beginning. So if there is probate assets, you really need to get probate open first before you start paying debts, paying bills, giving the card to someone, things like that. Before the house can be sold, before the belongings in the house are distributed amongst individuals, the probate process should be started. So again, there's no real rush, but again, everyone likes to have this wrapped up. Um, the longer the estate stays open, the longer there's thought about it. There's thought about the passing of the individual and what they meant to the family. So getting things wrapped up is generally in everyone's best interest. I'll come back to some questions real quick. But again, there's a lot of resources online. Kansas Legal Services and the Kansas Judicial Council have some online materials. There's also some IRS publications related to duties of executors and administrators. Those can all be consulted with. And again, a local attorney who practices, particularly in the area of probate, is helpful to walk you through that process, ensure that everything is complied with, creditors are paid, and then legal title does transfer. Again, this is particularly important as it relates to real estate, so that chain of title is preserved, and also with vehicles, that title gets recorded with the state and is protected. Is there any questions that anyone has at this time?
Josh, I have received no questions. Thank you so much for presenting this program. We will be sharing it with everyone online on the Adair Law YouTube channel. Thank you so much for your time, and we appreciate the information that you've provided.
Excellent. Thank you, everyone. Have a great evening.